automated and on-demand analytics and reporting capabilities available to flag non-compliance and risk. Comfy's readily available reports can be used for internal and external audit, gap assessment, and due diligence analysis. It supports in identifying risks and allows for a proper mitigation system to be set in place to avoid non-compliance. Mobile apps. Comfy is available on iOS and Android-based mobile apps to manage your regulatory compliance while you're on the go. Dedicated data server with AWS that acts as a repository for historic organizational data that serves as comprehensive databank of regulatory compliance documents. With its applicability across 100+ industries, regulatory compliance management becomes effortless with Comfy. Comfy's robust inbuilt mechanism ensures continuity and visibility of regulatory compliance in companies across the world. Apart from catering to various domains and modules, it can also be customized to suit specific needs. Let's take a quick look at Comfy's interface and usability. Comfy suggests applicable statutes for every branch of the organization, along with instant updates on new regulations and any changes. It customizes regulatory compliance assignment to users. Regulatory compliance tasks are allotted to a set of users who play the role of maker and checker for completion and approval of tasks respectively. Comfy tells a user on what, when, and how for completing any activity. Tasks are automatically triggered with adequate legal information, made available for accomplishing any activity with ease. An approval mechanism to verify and validate all tasks ensures a foolproof system. Upon task approval, the updated regulatory compliance status reflects in the dashboard in real time for comprehensive tracking. It really is that simple. Next is the dashboard feature, which provides a bird's-eye view of the regulatory compliance status, improving transparency and accountability levels across the organization. With its inbuilt report engine and extensive reports, Comfy acts as regulatory compliance repository and can retrieve data that dates back to 7 years. Needless to say, it is designed at par with industry standards. With Comfy, regulatory compliance management is now accurate and hassle-free. Reach out to us for a free demo. Comfy, your compliance selfie. In today's business scenario, as organizations re-strategize to improve profitability, one of the biggest challenges is achieving 100% regulatory compliance. The major hurdles faced are the vastness and complexity of standards, continuous amendments to regulatory compliance laws, and lack of robust digital tools. Besides, non-compliance may lead to legal exposure and prosecution of the board of directors. This can result in heavy fines and penalties and a drop in market value and share prices. Now companies can tackle these challenges with Comfy, a tech-enabled plug-and-play global compliance management system with Regulatory Compliance Advisor. Comfy is a product of Aparajita Group of companies, the #1 regulatory compliance company in India, offering solutions across key domains. Comfy is the only global compliance management system that enables companies to track, govern, and manage regulatory requirements, performance evaluations, and internal operations, thereby mitigating future risks. Comfy provides full regulatory compliance assurance and precise knowledge mapping with real-time updates. The technology is embedded with comprehensive legal knowledge and assists in mapping industry-specific laws with a host of other key features. A key highlight of Comfy is tracking regulatory compliance performance with a multi-dimensional dashboard for management review. This helps companies act proactively and reduces financial risks and liability costs, leading to improved stock value and customer trust. Some of the key USPs of Comfy are as follows. Comfy dynamically drives and manages regulatory compliance performance with auto-trigger, tracking, and escalating of regulatory compliance gaps. Comprehensive regulatory compliance knowledge covers all types and categories regulatory knowledge for effective compliance management globally. Easy-to-use intelligent, real-time, and color-coded dashboard and trend charts with drill-down capabilities. Timely auto-updates with notifications and comprehensive reporting and alert system. Automated and on-demand analytics and reporting capabilities available to flag non-compliance and risk. Comfy's readily available reports can be used for internal and external audit, gap assessment, and due diligence analysis. It supports in identifying risks and allows for a proper mitigation system to be set in place to avoid non-compliance. Mobile apps. Comfy is available on iOS and Android-based mobile apps to manage your regulatory compliance while you're on the go. Dedicated data server with AWS that acts as a repository for historic organizational data that serves as comprehensive databank of regulatory compliance documents. With its applicability across 100+ industries, regulatory compliance management becomes effortless with Comfy. Comfy's robust inbuilt mechanism ensures continuity and visibility of regulatory compliance in companies across the world. Apart from catering to various domains and modules, it can also be customized to suit specific needs. Let's take a quick look at Comfy's interface and usability. Comfy suggests applicable statutes for every branch of the organization, along with instant updates on new regulations and any changes. It customizes regulatory compliance assignment to users. Regulatory compliance tasks are allotted to a set of users who play the role of maker and checker for completion and approval of tasks respectively. Comfy tells a user on what, when, and how for completing any activity. Tasks are automatically triggered with adequate legal information, made available for accomplishing any activity with ease. An approval mechanism to verify and validate all tasks ensures a foolproof system. Upon task approval, the updated regulatory compliance status reflects in the dashboard in real time for comprehensive tracking. It really is that simple. Next is the dashboard feature, which provides a bird's-eye view of the regulatory compliance status, improving transparency and accountability levels across the organization. With its inbuilt report engine and extensive reports, Comfy acts as regulatory compliance repository and can retrieve data that dates back to 7 years. Needless to say, it is designed at par with industry standards. With Comfy, regulatory compliance management is now accurate and hassle-free. Reach out to us for a free demo. Comfy, your compliance selfie.
Good afternoon, ladies and gentlemen. It is my pleasure to welcome you on behalf of Aparajita Group of Companies to our 60 Minutes Compliance webinar. I would like to take this opportunity to welcome our 1,000 plus registered attendees who are a part of our session today. It is with great pride I would like to mention, we Aparajita have completed 20 dynamically powerful years in India. We were responsible for setting the tone for an organized compliance industry from the year 2000. Today, with a pan-India presence and humbly servicing 1,750 plus clients across 100 plus industries, we have also extended our compliance services to countries like Sri Lanka, Bangladesh, and Nepal. The 60 Minutes Compliance series was formulated a year ago, keeping in mind the vast complexities experienced by organizations and the workforce in India, on the non-availability of updated compliance knowledge across domains such as labor, industrial, and finance. It has been a continuous effort to provide legal perspective to the market at large through our webinar. Today, our topic for the session, Posh Act 2013, background, provisions, duties of employees, and FAQs. Before I proceed, there are a few points to be noted. Any questions on the subject discussed today can be typed under the Q&A box available at the bottom of your screen. We will try our best to answer each one of them. In case we run out of time, please email us your questions to the mail ID on which you received your invite for this webinar, and our legal experts will directly address them back to you through mail. The session is recorded and will be posted on YouTube fortnightly, which can be viewed and accessed easily. The link will be provided to you in our chat box. Moving forward, I would like to introduce our star speaker for today's session, Mr. K. Vardhan. A dynamic and competent professional with over 30 years of rich experience in HR, Mr. K. Vardhan is a name that needs no introduction to the veterans in the industry. Throughout his illustrious career, he is credited to have provided institutional clients with great consulting services, valuable legal opinions, and has appeared on behalf of them before various forums. Mr. Vardhan, who is a CXO at Aparajita Corporate Services Private Limited as Chief Consultation Officer, he is part of Aparajita's leadership team from 2005 and played a key role in stabilizing the flagship activity of compliance management services. He is also associated with renowned forums such as CII, Confederation of Indian Industry, EFSI, Employers Federation of Southern India, and NIPM, National Institute of Personal Management. Thank you, sir, for your continuous support in our 60 Minutes Compliance webinar series, and I hand over the forum to you.
Yeah, thank you, Faisal.
Thank you, sir. You are audible, sir.
Yeah. Is the slide visible?
Yes, sir. It is visible.
Okay. Thanks again, Faisal. Very good afternoon, every one of you. Extremely glad to get connected to you once again through this session. Almost, I think, should be 3 or 4 months since I met you last. Maybe in these 3-4 months, I think my colleague, Mr. Sridharan, was handling sessions on laws pertaining to EHS, Environment, Health and Safety. More maybe the industrial laws associated with with the labor laws. That is what he has been handling. This time, I think we thought we could handle a session on sexual harassment, given the importance of this act. Not only the provisions of the Posh Act, but I think this has impact on other significant legislations also. And I think women employment, yes, it has come into stay, and almost it is on par with men. Unfortunately, the number of cases is also going up because as I read the law journal on a monthly basis, I could see at least 1 or 2 cases pertaining to judgments relating to sexual harassment dealt with under the Posh Act. If the compliance is not done, I think the punishment is also a bit severe, actually, compared to labor laws, I would say. And more importantly, yes, earlier we have been handling several sessions on labor codes. Almost for the past 1.5 years, I think we have touched a lot of areas under the labor codes. But now, yes, the labor codes are very near it so far. So let us hope it is getting implemented as early as possible. But still, this labor codes, introduction of labor codes will not in any way impact this Posh Act, because this act is completely out of the purview of 29 legislations which are getting consummated into just 4 labor codes. So these are all certain reasons we just thought we could maybe disseminate information on Posh Act, which should be useful to the people in the industry. As Mr. Faisal said, yes, broadly, maybe I would like to touch upon the background. Maybe I have only one slide on that, the background for the enactment itself, and yes, then the provisions. Provisions, yes, that will take a bit of a time in this session. And yes, we will be discussing on the key terms which are defined, and the inquiry procedure, which is the integral part of the Posh Act again. Then some of the do's and don'ts. Maybe I would say it is both for employers as well as the internal committee. And final phase, the fourth point is on the other legislations, key legislations, which are dealing with this particular subject. This is how I'm planning to have the discussion today in this session. So now I think on your screens you can have a look at the background. I think see, prior to 1997, absolutely there was no mechanism for handling sexual harassment, particularly when it happens in a workplace, right? Industrial setup. But of course, the Indian Penal Code was there. It is still there. So people had to necessarily resort to Section 354, which is the assault or the criminal force to deter the public servant from discharging of his or her duties. That is what IPC 354 says. And Indian Penal Code 509, which is about the words, the gestures, or the acts which are intended to insult the modesty of women. So these are all the 2 sections under which, in fact, people, affected parties, the aggrieved persons would go into to get it redressed. So what has happened, I think it was in Rajasthan, one Banwari Devi, she was a social worker. She was attached to a department of the government itself, state government. And she was on an assignment to some place in Rajasthan in the state, where she noticed some arrangements for the marriage of a child. So the people were preparing for a marriage of a child. You won't believe the child's age was just 9 months. A 9-month-old baby, right, was getting ready for the marriage. So being a social worker, she objected to that. And understandably, the patriarchy system in that location, I think they got enraged, and they wanted to take revenge on Banwari Devi since she stopped the marriage. Unfortunately, she was gang raped. So still, she did not give up her fight. She wanted to file a case file a complaint with the police station, but she was not able to do so because again, the interpretation of these sections, section 354, 509, it was at the discretion of the police people, right? So she was not successful. But since on seeing her guts, no, in fact, these people were further enraged, and she was repeatedly gang raped. Then I think the NGOs and the other women organizations joined together and collectively they formed a platform called Vishaka. And a case was filed against both the state government as well as the central government. And finally, yes, Vishaka guidelines were given. We all know that. I think there were certain guidelines available for handling incidents of sexual harassment, particularly when it takes place in a workplace. So this is background, and these guidelines were followed by the industries. And of course, again, it took further 16 more years to come up with a law on this. Supreme Court very clearly said till such time a law is framed to handle this these types of cases, the guidelines ought to be followed. But yeah, I would say again it was not followed in letter and spirit, right? But yes, there were some guidelines under that judgment by the Supreme Court. And again, in 2012, we all know this happened in Delhi, the Nirbhaya case. I think I need not get into the details. Many of us would know on this. This also accelerated for a law. And the Supreme Court, since it came to know that there is no domestic law available to handle sexual harassment cases, particularly when it happens in workplace, I think they wanted to, they pushed the central government to have a separate law for this. Thus, the prevention of sexual harassment, or to put it right, sexual harassment of women in workplaces, within brackets, Prevention, Prohibition and Redressal Act. It was enacted and it came into force in 2013. Again, it was in December 2013 actually. So this is the background for the enactment. And now we will get into the second phase, which is about the provisions. So I would start with section 19. The reason being, this discusses the duties of an employer, right, under this act. So since we would like to discuss from this subject from the employer's perspective, from compliance perspective, I thought it would be appropriate if we have this as a base. So every employer is required to provide a safe working environment at the workplace. And yes, they have to make a display at any conspicuous place in the workplace, which should describe the penal consequences of sexual harassments. Penal consequences of sexual harassment and the order constituting the internal committee. So these things must be clearly displayed by the employer in a conspicuous place in the workplace. And the employer has to organize workshops and awareness programs, again, for sensitizing the employees on this, and orientation programs, not only for the employees, for also the members belonging to the internal compliance committee, right? And necessary facilities are also to be provided to the internal committee members, particularly when they handle the inquiry on receipt of a complaint. They may proceed with inquiry. So for that, I think necessary facilities should be provided by the employer, and they have to assist in securing the attendance of the respondent. The respondent is the person against whom the complaint is filed, right? Yes, again, attendance of the witnesses. I think the employer should help the internal committee in the inquiry. And they have to make available such information to the internal committee as it may require, having regard to the complaints made. So pertaining to that complaint, if they require any document and if it is available with the employer, I think if they seek it, then the employer has to provide it. and the employer has to provide assistance to the woman, aggrieved woman, if she so chooses to file a complaint in relation to the offense under IPC or any other law for the time being. So this is the advantage, since this aggrieved again woman, if she is an employee, then as employer, the employer has to support or assist the aggrieved woman in filing a case under IPC or any other law as the woman chooses, apart from dealing it through the IC in the workplace. And the employer shall treat sexual harassment as a misconduct under this. So once this should have been already done by the establishments, which is if they have certified standing orders in their establishments, they should have added this sexual harassment as one of the misconducts under the certified standing orders. They should have amended it. And the employers should monitor timely submission of reports by the internal committee. So what are the reports to be submitted? All those things we will see in the later slides. Now, again, this is a kind of summary. So organizing programs, having statutory displays, and the formation of internal compliance committee or internal committee, and facilitating the internal committee in the inquiry, or assisting the aggrieved woman. So she may come up with a lot of requests. So some of the requests, yes, they may have to help them. And the timely submission of reports. These are all certain things. I think all those things we will discuss in subsequent slides. And the seventh point is about other laws. The other laws, which are again dealing with this particular subject. This may not be the obligation of the employers, but still it is a significant aspect which is to be considered under the Posh Act. And again, yes, the object of the act broadly, this is an act to provide protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment and for matters connected therewith. I think this is very, very broader. Prevention should be there, then prohibition. I think beyond that, if something happens, then it provides path for redressal. So all the three aspects are there, and employers should ensure this is done in his workplace. And so sexual harassment is a key term which is defined in the section 2N of the Act, and it goes like this. It includes any one or more of the following unwelcome acts or behavior, namely physical contact and advances, or a demand or request for sexual favors, or making sexually colored remarks, or showing pornography, or any other unwelcome physical, verbal, or non-verbal contact of sexual. I think this does not require any further explanation. But this will not just stop with this list. I would say I think this can go beyond this also. So this could also include unwanted, deliberate touching, leaning over, cornering, or so the kind of interpretation is a particular act. When the complaint is received by the internal committee, then the internal committee has to decide whether this is really sexual harassment or not. If sexual harassment, then yes, the internal committee can take up the case for inquiry and come up with their findings. Unwanted sexual teasing, jokes, remarks, or questions, whistling at someone, and kissing sounds or smacking lips, touching an employee's clothing, hair, or body, touching or rubbing oneself sexually around another person. These are all again certain things. And this is one case law. This is by Delhi High Court. It says shouting by the male officer, right? So this can happen in an office setup. So a male officer shouted at his staff, who happens to be a female staff. Whether this will be considered as sexual harassment. In this case, court said no, this is not a sexual harassment. See, this could be a misbehavior. Shouting can be a misbehavior, which can be handled under different by different forum, but it is not to be considered as sexual harassment. So this is what the judgment given by Delhi High Court. And similarly, accused entered into the laboratory room of the complainant and snatched the material from her hands, threw it, and pushed her out of room. She made a complaint of sexual harassment, but committee concluded it was not so. disciplinary authority exonerated the accused. So that person was relieved, accused was relieved. Complainant challenged it in a writ petition. Right. So again, High Court concluded that physical contact or advances would constitute sexual harassment, provided the same is a sexually determined behavior. Right. So yes, again, this act may not be accepted in an office setup. This could again be a harassment and it could be deplorable, but this will not fall under sexual harassment. So the ICC cannot inquire on this. That is what the High Court also said. So again, the point is not all the complaints given by the woman will automatically be taken up. The ICC has to analyze whether this is a sexual harassment for falling under the definition as given under the Act, or it is something else to be handled by some other maybe disciplinary authority. And another important terminology in this Act is workplace. Again, as the name itself suggests, sexual harassment of women at workplaces. But again, this is wide, very wide, the definition. You can go through that. Maybe I would like to draw your attention to the portions which are underlined, so because that is about the private sector. Any private sector organization or a private venture, undertaking, enterprise, institution, establishment, society, trust, non-governmental organization, unit, or service provider carrying on commercial, professional, vocational, educational, entertainmental, industrial, health services, or financial activities, including production, supply, sale, distribution, or service. So almost everything is included here. And if you go through class 5, any place visited by the employee arising out of or during the course of employment. So as a part of her duty, she moves out of the workplace, right? So it can be transportation, in the transportation provided by the employer. So that journey will also be treated as workplace. So this is considered as an extended workplace, or the place where that person stays on duty related activity. So that will also be considered as workplace. So the workplace is not just limited to our office premises or our factory premises or any other establishment premises. So it can extend if the person goes on duty outside the premises of the establishment. And it can as well be the dwelling place, right? Particularly for domestic workers, they will be engaged as housemates. So whatever job they do for that house, right, that dwelling place or house will also be considered as workplace. But if any sexual harassment is reported, this will be handled by the local committee, which is to be formed by the district governor, right? So it will not be handled by any of the internal complaints committee, which would be available in an industrial setup. Now the term employee. So again, employee means a person employed at a workplace for any work on regular, temporary, ad hoc, or daily wage basis, either directly or through an agent, right? So again, contract workers, including a contractor. Again, it includes co-worker, a contract worker, probationer, trainee, apprentice, or called by any other such name. So any person who is there for it could be for training or for apprenticeship or for regular employment or through a contractor, any type of person. All these persons will be considered as employee, right? So this may not have much of an application, but the point here is, as we discussed earlier, if the employee chooses to file in case of sexual harassment, if the employee chooses to file a case with the police, then the employer should help, should assist. So in that perspective, this will assume importance. So maybe the employer may have to extend his assistance to even a training, to even an apprentice, right, to even a contract worker. So in that context, I think this is very, very significant. Otherwise, not much difference. And aggrieved one, this is very, very important, right? Because again, there must be a complaint. Only then the internal complaints committee can take action. That complaint should be primarily from the aggrieved woman. So who is an aggrieved woman? Section 2A discusses on this. In relation to a workplace, a woman, it does not say employee or worker. A woman, so any woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent. That's so any woman. So it could be even a customer coming to your workplace, right? There, maybe the employee, if that person happens to be a male employee, he indulges in sexual harassment of the customer, and who happens to be a woman. She can also even file a complaint, for which the employer of that workplace has to necessarily conduct inquiry through IC. That is the point here. So I think this term is very, very important, aggrieved woman. And in relation to a dwelling place or house, again, a woman of any age who is employed in such a dwelling place or house. Now respondent. So this is the person against whom the complaint is made, right? This is the person who is alleged to have committed sexual harassment. This is definition is given under section 2M. So again, the aggrieved woman and the respondent will be normally the parties as far as this act is concerned for inquiry. And other than whatever we saw as instances of sexual harassment, these things will also be considered as, because these things can lead to sexual harassment. Implied or explicit promise of preferential treatment. Suppose if the male boss gives some preference maybe to his woman subordinate, so that can lead to possibly sexual harassment. So this can also be considered as sexual harassment. So implied or explicit threat of detrimental treatment, not necessarily preferential treatment. So threatening. So implied or explicit threat of detrimental treatment can also be considered as sexual harassment. And the threat about her present or future employment status, again threatening, deter. And interferes with her work, or creating an intimidating or offensive or hostile work environment for her, or humiliating treatment likely to affect her health or safety. All those things can, again, as I said, we cannot just put it in a framework. So it is not limited to any specific set of activities. Maybe each and every circumstance we may have to analyze and come to a conclusion whether it involves any sexual harassment or not. And more importantly, I think this is the most important compliance activity to be done by the employer, failing which I think the fine particularly will be very, very high. So every employer of a workplace shall constitute an internal committee by order in writing. So it is there in section 4. And of course, we may have to read it along with section 6. That is the reason I have put section 6 also, which talks about formation of a local committee by the district officer. It very clearly says every district officer, normally the district collector, shall constitute a local committee to receive complaints from establishments in which there is no internal committee due to engagement of less than 10 employees. Right? Which means indirectly, if there are 10 or more, then that particular establishment has to, workplace has to necessarily form, employer of that workplace has to form an internal committee, right? But if there are less than 10 workers or employees working in that establishment, then I think that will be handled by local committee. The employer of that workplace need not form the internal committee as mentioned in this act. And more importantly, in Maharashtra and Telangana, registration for the internal committee is prescribed, but it is there only in these two states, Maharashtra and Telangana, right? I think what I understand is this can be done online, but registration is prescribed, but not in other states as of now. The next question would be, is it necessary that each unit of a company shall have an internal committee? Yes, all the units should have an internal committee separately, where the offices or administrative units of the workplace are located at different places or divisional or subdivisional level. The internal committee shall be constituted at all offices or administrative units, right? So whatever be the type of establishments, it could be a factory, it could be a mine, it could be a plantation, it could be an office, it could be an commercial establishment or any other administrative office. Yes, all those workplaces should have separate internal committee if they have more than 10 workers or employees employed in that location. And so what is the constitution of internal committee? There must be 4 members, right? So 1 member should be the presiding officer, who is necessarily a woman at senior level in that organization, right? And 2 more employees who are having experience in social work or kind of legal knowledge. And 1 person should be necessarily from NGO or any other association committed to the cause of women, or a person who has experience with the issues relating to sexual harassment. Out of the total 4, at least 50%, which means 2 persons, should be necessarily women. So again, the presiding officer should be woman. So out of the other 3, 1 should be woman at least. That is how it is. And the presiding officer, as well as each of the members, they will hold office for a period not exceeding 3 years from the date they were nominated. And yeah, these are all certain case laws, again by Allahabad High Court. Again, 1 member in the internal compliance committee for sexual harassment should be independent, preferably from NGO. I think we saw that, I think the 4th member, right? And the lady member of the internal compliance committee, not necessarily to be senior in rank of the C. She should be a senior lady member, not an issue on that. But it is not necessary that she should be senior to the complainant. The complainant means the agreed woman, right? It is not necessary. That is what this case law is saying. And Gujarat High Court, it says, yes, at least 1/2 of the members of ICC for sexual harassment are required to be women. So again, out of the total 4, at least 2 persons should be women, right? There could be a technical question whether the presiding officer, who is necessarily a woman, will be considered as a member, right? Because it talks about only members. Normally, when we say presiding officer or chairperson, we will not treat them as members. But for this purpose, otherwise, out of the 3, if it is 50%, I think we cannot have 1.5 persons. So maybe logically, it should be at least 2 persons out of the total 4. So we may have to include presiding officer also for this purpose. And even if there is no woman employee in an establishment, but more than 10 employees, whether the internal committee is to be constituted. Definitely, yes. Again, the point is, it is not only for the women employees working in that location. Other women, customers or anybody else can come in, right? So harassment can happen to them also. There will be a problem or difficulty in forming the committee. In such a case, if in a particular location, if there is no women employee, if they have branches, then they can consider having people from those branches as part of this committee for this location, that is workplace. Even if that is not possible, then necessarily for those people, if sexual harassment is reported, they have to approach the local committee, no other go. That is how it is to be proceeded. And can a company have one common committee? No, again, the idea is every unit should have separate internal committee separately. That is what is contemplated. But extraordinary situations, maybe it could be possible, right? And can multiple entities of the same group of companies, they have multiple entities operating in the same location, can they have one common committee? That is another question. Again, the idea is no, it should be separate committees. Only in exceptional cases we can go for that, right? Maybe we may have to provide information to the authority concerned properly. But as per the Act, it is one committee for each unit, each branch. And yeah, I think this judgment again will throw the significance of the compliance under this Act. So it is a recent judgment. Again, it is in Madhya Pradesh. So the High Court has slapped a penalty of rupees 50,000 on Medanta Hospital, Indore, for not having formed the internal compliance committee. Again, as a result, the court has also directed the hospital to pay a compensation of 25 lakhs 25 lakhs to the complainant for failing to address her complaint of sexual harassment. The order was passed in concurrence with the report that was filed by the local complaint. See, local complaints committee has to send a report every year. And they have also recommended for this, it seems. So based on that, I think the court has slapped this 25 lakhs. Again, they have mentioned the reason as for having failed to address her complaint of sexual harassment. But had they formed the internal committee, they would have conducted it. Right. So the point here is the non-formation of internal complaints committee, I think, has led to this state of affairs. Right. So again, it is not just like 5,000 rupees or 10,000 rupees. Right. The Act itself prescribes a maximum of 50,000 for non-formation of ICC, but compensation can be under other legislations also. We will discuss that maybe in the last phase. And one more case, again, this will be much higher. Again, I would like to draw your attention to maybe the penultimate paragraph, which starts with the Madras High Court rejected all other claims. There, the last line where I've underlined, she lost on account of the non-constitution of the committee. The court was of the view that the grant of an amount equivalent to the severance benefit of 1 crore 68 lakh. It is not 1 lakh, it is 1 crore 68 lakh. Interestingly, please look at the first line of the paragraph on your right side. The petitioner, the claim of the petitioner is under 12 heads, and the total claim is 28 crore, of which what was sanctioned is merely 1 crore 68 lakhs, right? But when we compare it with 28 lakhs, it looks small. But for a company to pay 1 crore 68 lakh, no, I think so. Please understand the enormity of this compliance activity. If it is not done, so if a particular workplace, if it is ought to form an internal complaints committee, please ensure it is done, right? Because I think this is considered to be very sensitive subject, and I think the fine can go up like anything. So I think just to explain that sensitivity attached to this and the quantum of fine which is being imposed, I just thought I could share these two case laws for the benefit of the participants. I move on. So again, who can make a complaint? Again, the complaint can be made only by the aggrieved woman. But of course, there are exceptions. So those exceptions are here mentioned. So her relative or friends or co-worker or an officer of the National Commission for Women or State Commission or any person who has knowledge of the incident in case of physical incapacity. So only in case of physical incapacity of the aggrieved woman, these persons can file a complaint on behalf of the aggrieved woman, right? Second para, it talks about the mental incapacity because of the sexual harassment. If that aggrieved woman is mentally incapacitated, then who can file a complaint on her behalf? That is what is described under second. It is straight away there. You can have a look at section 9 and rule 6 of the Prevention of Sexual Harassment Act. There you can see it, right? And thirdly, any person who has knowledge of incident, they can file with her written consent in case aggrieved woman is unable to make a complaint for some reason. If she is unable to do that, then with her written consent, other person who has the knowledge on this incident can file a complaint. And finally, any person who has knowledge of incident with the written consent of her legal heir in case of death of aggrieved woman. So again, as a result of the sexual harassment, the aggrieved woman is dead. So again, the consent must be obtained from the legal heirs of the aggrieved woman. Then I think any other person who has knowledge on that, they can file a complaint on behalf of the aggrieved woman. Again, to whom the complaint is to be made and what is the time limit for making complaint. So complaint is to be made to the internal committee, and it should be done within 3 months, right? And the internal committee, in extraordinary circumstances, they can extend the timeline for another 3 months, not more than that, right? And while filing the complaint, 6 copies of the complaint should be given to the internal committee, and out of the 6 copies, I think 1 copy will be given to the respondent by the internal committee, right? Now, can the complaint be made against the employer? So can the sexual harassment complaint be made against the employer himself? It is possible, but in that situation, the internal committee will not handle the case. It will be done by the local committee. So the complaint is to be filed by the agreed woman to the local committee and not to the ICC. If the ICC is approached, I think the members of the ICC may have to direct the woman to go to local committee. And rule 7, should the copy of the complaint be shared with the respondent? Yes, it is to be shared. The complaint, I think the agreed woman will give 6 copies, of which 1 copy is to be shared with the respondent, and it should be done within 7 days, within 7 working days by the internal committee. Again, everything has got a timeline here. And is there any time limit for the respondent to file his reply after receiving the complaint? Yes, he or she can take 10 working days for responding to the complaint, right? So not more than 10 working days. And can the complaint, once filed, be withdrawn? Yes, that is always possible. The agreed woman can withdraw after filing the complaint. And if the agreed woman wants to quit the services of the company itself, for some reason, after filing the complaint, is it possible? Yes, it is possible, and she can be relieved. And what if the complaint is against an expat? So I think now expats can also work commonly along with other persons, with Indian citizens. So is it possible? What if any complaint is reserved against the expat? Yes, again the same procedure, because all these laws will be equally applicable to them also. But what is suggested is, apart from being heard by the internal committee, a complaint can also be registered with the police. And what are all the conditions in conducting inquiry? I think Rule 7 discusses a lot of points, of which these are all certain points that are related to conducting inquiry. So inquiry shall be conducted in accordance with the provisions of the service rules, right? If the service rules are available, and the complaints committee shall make inquiry into the complaint in accordance with the principles of natural justice. So even when we do the inquiry, domestic inquiry under the standing orders, we will necessarily follow the principles of natural justice. The same thing is to be followed here also. And during inquiry, at least 3 members, including the presiding officer or the chairperson, should be present for hearing the inquiry, right? So the internal committee will at least have 4 members, including the presiding officer. So out of the 4, at least 3 persons should be there, right? Maybe as a part of inquiry committee there, right? And of the 3, 1 should be necessarily the presiding officer or the chairperson. And normally, what are all the principles of natural justice? I think many of you must have heard about these Latin terms: nemo jude esse in propria sua causa, which means no person shall be a judge in his own cause, right? And audi altrum partem, which means hear both the sides, hear the other side also, fair hearing. And normally, when we say principles of natural justice, we talk about only these two things, but this will not just stop with this. Every step, there must be reasonableness. Every stage, every action, right? So assume the internal committee is sending a notice for providing the date of inquiry, but on the first time the respondent does not appear. First day itself, the committee cannot go for ex parte inquiry, right? So they may have to give that person one more opportunity. So how many opportunities are to be given? I think there will not be any specific number, but as far as this particular act is concerned, they have given the number for 3 consecutive hearings. If the parties do not attend, either the respondent or the agreed woman, they can set it ex parte. That is what they are saying. But still, I am doubtful how they come up with the number, because this will get adjusted according to the gravity or maybe the nature of the offense. But still, it is mentioned here. Maybe we'll see it in a later slide. Whether there is any written codification of law regarding inquiry procedure. No, right? Even under standing orders, it is considered as a judge-made law. There is no written codification, right? So it is based on precedents, and it is known as judge-made law. So the same thing is to be followed by the internal committee also. And can the complainant or the respondent bring legal practitioners during the inquiry proceeding? Right? Again, the sub-rule 6 clearly says no, it is not possible. Right? At least in the domestic inquiry, yes, there also it is not possible unless and otherwise the certified standing orders provide for that. But still, if one party is represented by a legal practitioner, then if the other party requests, then the other party should also be allowed to be represented by a legal practitioner. Again, that is part of principles of natural justice, right? I think that will, in extraordinary circumstances, be applicable here also. But as per Rule 7.6, it very clearly says that allowing a legal practitioner is not permitted, right? It is clearly prohibited here. And so again, what are all the various stages of inquiry procedure? The internal committee has to make sure that the respondent understood the charges. So maybe before the beginning of the inquiry, it is better the committee members once again read out the charges against that person, right? And get his acknowledgement also. And to ascertain whether the respondent accepts the charges or denies it. So there can be acceptance, there can be denial, there can be partial acceptance and partial denial. That is possible, right? But it needs to be very clearly ascertained before proceeding. If the delinquent workman accepts the charges and his admission is to be recorded, and the inquiry there itself can be closed, right? But of course, duly getting the signatures of all the parties concerned. And however, in cases of grave charges, which is likely to entail severe punishment, it is better to conduct the inquiry in full, not to close it in the beginning itself, right? And request for adjournment, if any, by any of the parties, if it is valid, then it can be accepted by the committee. And witnesses are to be examined, and opportunity for cross-examination by both the parties shall be provided. And so what if the respondent alleges bias on an internal committee member? Again, if there is an allegation like this, then I think that will be brought to the knowledge of the disciplinary authority of the company concerned. And till such time they take a decision, the inquiry shall not be proceeded. That is how it is. So after that, they can proceed. Yeah, this is Rule 7.5. Can the internal committee issue ex parte order? I think this is what I discussed. The compliance committee shall have the right to stop the inquiry proceedings or to give the ex parte decision if the complainant or respondent does not attend 3 consecutive hearings. I think this is the reason I put a question mark there. Before giving termination or ex parte order, compliance committee should serve at least 15 days notice to the person's concerned. Now, can the aggrieved woman seek any other relief during the inquiry proceeding? Yes, it is possible. She can request for a transfer, because of the sexual harassment, she may not like to continue in the same place, and probably she may not feel comfortable even to attend the inquiry. So she may request for a transfer, and she may request for leave also sometimes. Up to a period of 3 months, yes, the leave is to be sanctioned if there is a request. And she can also seek transfer of the respondent, not her transfer or love. She can also ask for a transfer of the respondent. That is also possible. Please go through section 12 and Rule 8. I think that will discuss all these points. And again, what is the time limit for completion of inquiry and submission of report? So inquiry shall be completed within 90 days. So after the receipt of the complaint, the compliance committee has to conduct the inquiry, and it shall be completed within 90 days. And they have to submit their findings, that is the report, inquiry report, within 10 days after the completion of the inquiry. So that is how it is. Then determination of compensation. See, when they receive the complaint, yes, they can in the first place go for kind of a conciliation. They can ICC can make an attempt whether it can be settled between the parties. But conciliation shall not be based on money, right? But money can be prescribed as a punishment, maybe as a fine, after conducting it. That is possible. But for conciliation, for settling it before proceeding with the inquiry, yes, they can still go for conciliation, but that should not be purely based on money, So again, so what are all the points that are to be considered if the quantum is to be fixed after conducting the inquiry, maybe as a punishment or as a fine, something like that? Then these are all the things: the mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman. The loss in the career opportunity due to the incident of sexual abuse. After the incident, the person, aggrieved woman, may not be in a position to take up employment at all. She may lose the opportunity. Then medical expenses incurred by the victim for physical or psychiatric treatment, right? The income and the financial status of the respondent also, that is also to be considered, and the feasibility of such payment as one lump sum payment or in installments. All those things are to be considered before determining the compensation under Section 15. And Rule 9, it talks about what are all the punishments. Again, if there is if there are service rules and similarly certified standing orders, whatever punishment prescribed, prescribed there, they can go for it. I think it should be proportionate again. But if there is no such list of punishments available, then I think the committee can suggest written apology or warning or reprimand or censure, withholding of promotion, withholding of pay rise or increments, terminating the respondent from services of the person, and counseling session. They can also recommend for a counseling session, and or also they can also suggest for carrying out community service by the respondent. Again, it is a case law by the Delhi High Court. Termination of services, right? Again, when we say termination, it's a capital punishment, right? So we may have to understand the gravity of the offense. Only then we can come to that conclusion. But it is possible. It is justified. And delay in complaining sexual harassment is not fatal. See, we saw that the complaint shall be given within 3 months by the aggrieved woman. That is what we saw. But if there is some delay, I think that will not be again fatal, right? If there is some proper reason for the delay, then that will be normally accepted. Is it obligatory that the internal committee must make its recommendations? Yes. Again, for taking action as a misconduct in accordance with the service rules or the policy of the company, or for making deductions if compensation is prescribed, right? To make the deduction under Section 13, I think the recommendation is to be provided by the complaints committee. It could be either internal committee or the local committee. And can the internal committee recommend disciplinary action against the complainant for false or malicious complaint? This is also always possible. Yes, they can make a complaint, and the IC can make a recommendation for taking same type of action, right? So complaints committee may recommend to the employer for the same action to be taken against the complainant in case of false complaint or false evidence made, right? But see, making a false complaint or malicious complaint is different from difficulty in proving the case, right? So both are different. Let us understand that also. And can the respondent or the aggrieved woman prefer appeal after the conclusion of the inquiry by the complaints committee? After they give the recommendation, can the aggrieved party, right, could be aggrieved woman or the respondent, can they go for appeal? Yes, they can go for appeal, right? Appeal can be preferred within 90 days, right? And it is in accordance with the service rules. In case of application of Standing Orders Act, then it will be, I think, appeal. I think the person has to approach the authority prescribed under the Standing Orders Act. I think normally the labor court will be there. Should the internal committee submit any periodical report? Yes, whether it is the internal committee or the local committee, every year in respect of a calendar year, right? So in respect of a calendar year, they have to prepare the report, which means report will normally contain the number of cases came up during that year, and the number of cases disposed of, and number of cases kept pending for a period of exceeding 90 days, right? And the number of awareness sessions conducted, right? Awareness sessions again can be conducted both by the employer as well as the internal committee, right? So all those details shall be there. That report shall be, because there is no any specific format prescribed. Only these data are to be there in the report, and they have to submit it. The IC will submit it to the employer. The local committee will submit it to the district officer, right? And the employer in turn has to include the details provided by the internal committee in their annual report, which is being prepared under the Indian Companies Act. I think this is what I said in the beginning, because this has linked to other legislations also significantly. So should the employer submit any periodical report? Yes, employer shall include the number of cases, if any, and their disposal under this act in the annual report of the organization. And if no such annual report is required to be prepared by the employer, there can be certain companies for which there is no mandate to prepare such annual report. Then those employers shall intimate only the number of cases filed, if any, to the district officer. They need not bring it under annual report as part of annual, because they will not prepare annual report at all, because they are not required to do so. So they may have to provide only information relating to the number of cases and its disposal, and they have to send it to the district officer. And prohibition of publication of complaint and see, this should be kept confidential. Should the information about the complaint and the inquiry be kept confidential? Definitely, right? Again, if it is not done, I think punishment is very specifically prescribed for that also. It should be kept confidential. And what are all the penal consequences in case of violation? I think we discussed. As per the act, yes, it is 50,000. And specifically for non-maintenance of confidentiality, it will be 5,000 for each person of the company, whoever is involved. That is how it is given. But the quantum punishment is prescribed in other legislations also. That is the reason, in fact, we saw, I think in one case it went up to 25 lakhs. In another case, it went up to 1 crore 68 lakh. Yeah, I think we have completed the provisions, the second phase. The third phase is the do's and don'ts, particularly for compliance committee, but some of these points will be applicable relevant for the employers also, right? So creating awareness about the presence of internal committee and make known the complaint procedure, right? How it is to be done, and ensure body language of every member communicates complete attention, particularly when the inquiry happens. These are all suggested. Reject set ideas and stereotypes on how the complainant or respondent should appear or act. It is none of their business, right? Be open to the fact that sexual crimes are committed in privacy and eyewitnesses may not be existing or forthcoming. So I think this is the sensitivity attached to this type of cases. And ensure safety for complainant, friends and supporters. Handle complaints in a confidential manner and time-bound manner. Understand it could be difficult for the women to talk about anything sexual. Hence, there can be long time interval between the harassment and the actual complaint. Let us understand that also as part of ICC members. And understand only one out of many may be subject to harassment. The complainant has at stake her personal life and career. Therefore, drawing up similarities or generalization shall be avoided. I think these are all certain do's for the committee, and don'ts. Do not guide or lead the complainant to make statements. Do not insist on detailed description of the harassment. Instead, this could increase this could increase the complainant's trauma. Don't interrupt or allow interruptions when conversing with the complainant or the respondent during the inquiry, because I think three members will be present. They themselves will be three, and two parties will be there. At least 5 persons will be there. Don't determine the impact of the harassment on the complaint. Don't get aggressive. Don't discuss the complaint in the presence of the complaint. So if at all, if the members want to discuss within themselves, please do not do that in the presence of either the complainant or the respondent. And don't allow the third party to enter into the room where you conduct the inquiry as part of ICC member. And this is a human rights issue. Therefore, I think when we say sexual harassment, I think, yes, we saw some sections under Sexual Harassment Act as well as under IPC, but this is against Article 14 also. This is against Article 15, right? So equality of law or equal protection of law. It is against that, Article 14. Again, Article 15, it is about discrimination based on religion, race, caste, or gender. So it is against it. And it is also against fundamental rights, Article 19. So this one act, I think it is not only an offense under the Posh Act, which is specially enacted for this purpose, but it could simultaneously be violative of provisions of other significant legislations, including Indian Constitution. So we come to the last phase, some of the other legislations which may have impact because of this. So once this is done, as I said in the beginning, yes, there will be some implication on standing orders, right? Because sexual harassment, if it is already added as a misconduct, then absolutely no issues. If it is not done, then as employer, we may have to amend our standing orders, including this sexual harassment also as a misconduct. And yes, under standing orders, when we do the domestic inquiry, it will be based on principles of natural justice. The same thing is also to be followed, same procedure here by the ICC when they do the inquiry. And punishment as suggested in the standing orders. If list of punishments is not there, then I think they can go for any other punishment which is mentioned in the Posh Act. So this is with respect to standing orders, and this is with respect to Companies Act. So there is a mandatory disclosure prescribed under Section 134 of the Companies Act, right? So it's a statement stating that the company has complied with the provisions relating to the constitution of ICC under Posh Act, right? And interestingly, please see here, for contravention, if it is not done, ₹3 lakh for the company fine, and 50,000 for the officer in default. So this is under Companies Act, but for the same activity prescribed under Sexual Harassment Act. So please do not take it very light. Formation of internal committee, if it is not done in your company, please do that, because this is very, very important actually, particularly from Companies Act perspective. This is very important. And yes, for the mandatory disclosure, there are certain companies which are exempted. One-person company and small companies are exempted. Then this is a case law. It does not impact directly on the provisions of the Gratuity Act, but this is a case law where it said for sexual harassment, yes, the forfeiture of gratuity is justified, right? So normally it cannot be forfeited, right? See, the reason being, you may be aware that moral turpitude is one of the causes for forfeiture of gratuity, and sexual harassment is considered to be a kind of moral turpitude, right? But again, depends upon the nature of that offense and its gravity. But again, I'm saying, so this the forfeiture of gratuity can be done in case of sexual harassment. And yes, this will have impact on code on wages. Yes, codes are not implemented, but if implemented, conviction for sexual harassment can be a cause for disqualification for bonus, right? So there is a link to bonus also. And finally, there is a link to the Industrial Disputes Act, which is considered to be the backbone of entire set of labor legislations. Whether Section 33, I think you must be knowing about Section 33 under Industrial Disputes Act, which talks about maybe pending inquiry, whether changes can be done in the service rules. No, it is not possible. But maybe with special permission, if it will not affect the dispute, right, or subject matter of the dispute, then that can be done, right? That is how that is what is mentioned under Section 33 of ID. And it also discusses about the punishment for a misconduct connected to the dispute for which the proceeding is on. It could be conciliation, it could be arbitration, or it could be a proceeding in a labor court, right? But if some misconduct which is not connected to the dispute, for that punishment can be obtained, right? But otherwise, special permission should be obtained. Only then it can be done, if at all, if they want to proceed with the punishment for the misconduct which is connected with the dispute. But that type of special permission under Section 33 is not required in case of punishment under Sexual Harassment Act, because the complaints committee itself is considered to be having powers of the court, right? So it cannot be countenanced in facts and law. So this is again a judgment by Madras High Court. Fine, I think we have come to the end. I just thought I could share some of these provisions under Posh Act this time in this session. I hope you would have enjoyed the session. If you have any questions, yes, I'm ready to address it. Now it is over to you, Faisal.
Thank you so much, sir. It was a very insightful and very intuitive session for a lot of our people who have been attending this program. And there's a good number of comments also that has come in for this session, sir. So we have some questions. Can we turn on the questions right now, sir?
Yeah, we can take it up now.
Yes, sir. So there is a question from Abdul Qadir. Our internal POSH committee has completed 3 years. Now, what is the procedure to change the committee members? Do we have to inform anyone?
No. See, if it is for the entire set of members, if the period goes beyond 3 years, yes, you may have to nominate a new set of members. And yes, that order of nominating a new committee members should be displayed in the organization, in the workplace, right? I don't think it needs to be filed with any of the authorities.
All right.
Yeah.
Thank you, sir. Srimata Mukherjee has a question. Can a company set up one central POSH committee for multiple branches across different states?
I think we discussed during the session also. What is contemplated is separate committee for each unit, right? That is what is contemplated. But if for extraordinary reasons, if it is to be clubbed, then I think we can do that. No other go. Yeah, but what would be appropriate is it is better to have a separate committee for each unit, right?
Right.
Yeah.
Narayanan has a question. We have constituted a compliance committee with members as prescribed by the Act, which takes care of all of our 18 plants across the country. Is it in line with the statutory requirement? Please clarify.
No, I think almost the same question. No, yes. I won't say this is in line with the statutory provisions, because each unit shall have a separate committee. But for unavoidable reasons, for valid reasons, if you are having a common committee, then that is fine, right? But I don't think that needs to be informed to any of the authorities concerned, unless and otherwise specifically if there is any question from the government. Because again, the authority is not common as far as this act is concerned. When we say Shops Act, even if it happens to be a state-specific legislation, for each state, the labor department will be the authority, right? Yes. Similarly, maybe if you take Contract Labor Act, it could be state labor department or it could be central labor department. That is also possible, right? Yes. But as far as this act is concerned, we cannot specifically say this is this is under Labor Department, or this is under PF, this is under ESI. No, it is not so, because state to state, the authority could differ. In one state, it could be the police department. In another state, it could be directly the district collector. In another state, it could be, I'm not very sure, the Department of Women and Social Welfare. So for state to state, this will differ. There is no common department which will have jurisdiction. So we may have to look at the notification issued by the state specifically to understand this. But of course, as per the Act, no filing is required. This is just additional information to the participants.
Okay.
Yeah.
So this is another question by Srimata. Is there a statutory requirement for the ICC committee to conduct meetings quarterly, half-yearly, annually, even though there are no complaints received?
No, nothing of that sort is prescribed specifically.
Yes.
Right. So they can also create awareness as to the existence of the committee among the employees in that workplace. So for that, they can take whatever action they like. So I would suggest, if they can have a kind of meeting, if once in 3 months, if they can have a meeting, then that is fine, or at least once in 6 months, right? But nowhere it is mentioned, no periodicity is mentioned in the Act.
Yes.
Yeah.
Kaveri Ghosh has a question. My company will file the annual report to district magistrate for the first time. I want to know where the same need to be filed in that way. As I am new to the organization, we don't know where to submit the annual report, either by mail or by hard copy submission.
Yeah, see, there are two things. One is companies which are required to prepare annual reports. The Act says that the details received from the internal complaints committee are to be incorporated in the annual reports. Nowhere it says that it should be further, the employer has to submit the annual report to the district collector or somebody else. It is not specifically said. But only with respect to those companies who are not mandated to prepare annual report, they may have to provide just the details about the sexual harassment cases in that calendar year to the district officer. So it is very clear only with respect to the companies which are not required to prepare on annual report. They may have to provide the details to the district officer. But as far as those companies which are required to prepare annual report, it is sufficient if they incorporate the details in the annual report itself. I think there is no specific prescription for submission of that annual report to any authority.
Yes.
Yeah.
Neetu R. Kumar has a question. After concluding the investigation by the ICC, the detailed report will be submitted by the ICC. Do we have to give the copy of the report to the complainant?
The copy of the report is to be provided to both the parties, not just the complainant. It is also to be provided to the respondent, right? And it is also to be provided to the employer, that is the disciplinary authority, along with their recommendations. ICC recommendations.
Okay.
Yeah.
Amar Singh has a question. After completion of tenure of ICC, we can nominate the same members for a continuous period or not?
I think there is no bar. Specifically, there is no bar.
All right.
Yeah.
Tushar Shah has a question. Whether there is any need to put up penal provisions on notice board if company has circulated it on its email, as well as put it up on local area network or cloud services.
Yeah, penal consequences are necessarily to be displayed.
Yes, sir.
Yeah, see, apart from disseminating the information through whatever electronic mode you have in your company, please display it in some conspicuous place in your establishment. Yeah.
Now, Chelamal has a question. Can the aggrieved woman complain in more than one forum for the same complaint?
No, the possibility is, yes, that this person can approach ICC under Posh Act. They can approach, she can approach police department under IPC. These are all the two things available. Yeah.
Now,
sorry. More importantly, the provisions of Sexual Harassment Act is in addition to all the available existing legislation, and it is not in derogation of any existing law. So this will operate simultaneously along with the other existing laws. But it is a choice. She can just stop with making a complaint with ICC under Posh Act, or they can move, the person can move IPC also. It is also possible.
Okay. Thank you, sir, for the clarity.
Yeah.
Satish Kumar has a question. According to Section 6, the employees means female employee or inclusive of both genders?
Both genders.
Both genders.
Yeah.
All right. Vanita Agrawal, if a partnership firm and a proprietorship need to form ICC if they have a number of 10 or more employees?
Yeah, sure. See, though we use the terminology company, yes, this will be equally applicable to partnership firms also.
All right.
Yeah.
Thank you, sir. So Surinder has a question. Can a male or a transgender LGBT also file complaint against a woman boss?
That's an interesting question. Again, I would draw the attention to the very name of the act. It clearly says sexual harassment of women at workplace. That is the reason I said these two terms are very, very important, both women and workplace. Right. So maybe fortunately or unfortunately, harassment against men or any other gender, I don't think that will come under the scope of this act. There could be other possibilities, but not under this act.
Yes, sir.
Yeah.
In case of one ICC is constituted for a number of entities in a single corporate building, from whom should approval be taken?
No, as I said again, no specific authority is prescribed. No approval from any external authority is required. The company, the employers, it is the responsibility of the employer to form a committee, and the order of such formation of committee shall be displayed, because the information should pass on to each and every employee of that establishment. There it stops. There is no any mandate to inform it to any external authority, right? But government, through the authority concerned, they can approach the company if they want some details from a specific company. It is possible.
It is possible. Okay.
Yeah.
There's another question. During inquiry period, will he be on suspension or he will be paid regular salary?
No, that depends upon, again, the gravity. It is possible this can be done pending inquiry also. It is possible.
Yes.
Yeah. See, that is how we follow under domestic inquiry. I'm just saying that only. The act does not talk anything about that specifically.
No.
Yeah. So since this inquiry by ICC is also almost similar to the domestic inquiry, so we can follow that.
Yes. Now Rahul has a question. If victim needs leave for 3 months, then will the leave be considered paid, or is it a leave without the pay?
It is a paid leave, and it is in addition to all other privileges for which she is entitled to.
Yes.
Yeah.
I'm just going
So we'll take one more question.
Yes, sir.
Yeah.
If ICC has total 4 members, in case of any complaint, if 50% member of ICC are considering, act have responded as sexual harassment, however, remaining 50% member are not agreeing with it, what will be the solution in such case?
No, see, committee, as a committee, they have to come to a conclusion. See, they may have differences within themselves, right? But finally, the report has to go from the committee. It is a kind of joint report to the disciplinary authority. That is the employer. Normally, the employer.
Okay. Thank you, sir. I think at this stage, we have come to an end of all the Q&As.
Yeah.
So thank you so much, sir, for coming on board with 60 Minutes Compliance and giving us your insight on the Posh Act. And we look forward to having you on many more of our webinar sessions. And I'm pretty sure the audience is also looking forward to the same.
Sure. Thank you so much, Faisal. And thanks again to all the participants for sparing your time. We will meet up with another session. Thank you. Bye-bye.
In today's business scenario, as organizations re-strategize to improve profitability, one of the biggest challenges is achieving 100% regulatory compliance. The major hurdles faced are the vastness and complexity of standards, continuous amendments to regulatory compliance laws, and lack of robust digital tools. Besides, non-compliance may lead to legal exposure and prosecution of the board of directors. This can result in heavy fines and penalties and a drop in market value and share prices. Now companies can tackle these challenges with Comfy, a tech-enabled plug-and-play global compliance management system with Regulatory Compliance Advisor. Comfy is a product of Aparajita Group of Companies, the #1 regulatory compliance company in India, offering solutions across key domains. Comfy is the only global compliance management system that enables companies to track, govern, and manage regulatory requirements, performance evaluations, and internal operations, thereby mitigating future risks. Comfy provides full regulatory compliance assurance and precise knowledge mapping with real-time updates. The technology is embedded with comprehensive legal knowledge and assists in mapping industry-specific laws with a host of other key features. A key highlight of Comfy is tracking regulatory compliance performance with a multi-dimensional dashboard for management review. This helps companies act proactively and reduces financial risks and liability costs, leading to improved stock value and customer trust. Some of the key USPs of Comfy are as follows. Comfy dynamically drives and manages regulatory compliance performance with auto-trigger, tracking, and escalating of regulatory compliance gaps. Comprehensive regulatory compliance knowledge covers all types and categories regulatory knowledge for effective compliance management globally. Easy-to-use intelligent, real-time, and color-coded dashboard and trend charts with drill-down capabilities. Timely auto-updates with notifications and comprehensive reporting and alert system. Automated and on-demand analytics and reporting capabilities available to flag non-compliance and risk. Comfy's readily available reports can be used for internal and external audit, gap assessment, and due diligence analysis. It supports in identifying risks and allows for a proper mitigation system to be set in place to avoid non-compliance. Mobile apps. Comfy is available on iOS and Android-based mobile apps to manage your regulatory compliance while you're on the go. Dedicated data server with AWS that acts as a repository for historic organizational data that serves as comprehensive databank of regulatory compliance documents. With its applicability across 100+ industries, regulatory compliance management becomes effortless with Comfy. Comfy's robust inbuilt mechanism ensures continuity and visibility of regulatory compliance in companies across the world. Apart from catering to various domains and modules, it can also be customized to suit specific needs. Let's take a quick look at Comfy's interface and usability. Comfy suggests applicable statutes for every branch of the organization, along with instant updates on new regulations and any changes. It customizes regulatory compliance assignment to users. Regulatory compliance tasks are allotted to a set of users who play the role of maker and checker for completion and approval of tasks respectively. Comfy tells a user on what, when, and how for completing any activity. Tasks are automatically triggered with adequate legal information, made available for accomplishing any activity with ease. An approval mechanism to verify and validate all tasks ensures a foolproof system. Upon task approval, the updated regulatory compliance status reflects in the dashboard in real time for comprehensive tracking. It really is that simple. Next is the dashboard feature, which provides a bird's-eye view of the regulatory compliance status, improving transparency and accountability levels across the organization. With its inbuilt report engine and extensive reports, Comfy acts as regulatory compliance repository and can retrieve data that dates back to 7 years. Needless to say, it is designed at par with industry standards. With Comfy, regulatory compliance management is now accurate and hassle-free. Reach out to us for a free demo. Comfy, your compliance selfie.